In the case of Delaware v. Prowse, an officer stopped an automobile driven by Prowse, even though he acknowledged that prior to the stop he hadn't observed any traffic or equipment violations or any suspicious activity, and that he made the stop solely for the purpose of checking the driver's license and registration. The officer was found to not be acting on any standard guidelines or procedures related to current or warranted document spot checks at that time. The officer allegedly smelled marijuana while approaching the car and ended up seizing marijuana on the floor of the vehicle that was in plain view. The trial court allowed the suppression of the marijuana, claiming that the stop and detention were unreasonable and therefore violated Prowse's Fourth Amendment rights. It also held that stopping an automobile and detaining its occupants constitute a seizure, which was completely unwarranted in this situation. It was stated that the state's interest in discretionary spot checks as a means of ensuring the safety of its roadways does not outweigh the resulting intrusion on the privacy and security of the persons detained. In this case, however, the state of Delaware urged that patrol officers be subject to no constraints in deciding which automobiles can be stopped for a license and registration check, because of the exact opposite. I fully agree with the outcome of this case. The officer stated that I saw the car in the area and wasn't answering any complaints, so I decided to pull them off. If that was to be allowed by law enforcement, anyone at any time could be pulled over for no reason. Things such as racial profiling would become a norm due to police not having to justify their actions. I feel as though this is one of those cases that needed to happen in order to keep law enforcement somewhat grounded and reminded that there are policies and procedures that need to be followed.